necesito más. Te crees mucho, lo sé. Sé que te digo, sé. Pero hay más en Instagram. Si tú no quieres beber, tengo fila hasta tres. No te necesito más. Te crees mucho, lo sé. Sé que te digo, sé. Pero hay más en Instagram. Te crees más de lo que eres. Pero en el mundo, lo que mujer me la creía. Hasta ese día que me engañaste. ¿Qué más? Reciclaba amores y estabas tú. Te necesitaba, ya no. Fueron tantas flores, pero tu actitud con esa espina dolió. Después de todos los paris me llamas, diciéndome borracha que me quieres más. Y ahí yo que tu amiga me cae. Lo que está prohibido lo aprovechan más. Si tú no quieres ver, tengo filas hasta atrás. Más, te crees que no lo sé. Sé que te digo, sé, pero me vas en Instagram. Si tú no quieres ver, tengo filas hasta atrás. No te necesito más. Te crees que yo lo sé. Sé que te digo, sé, pero me vas en Instagram. Lo que sabes que no pude ver, que eran tus amigas, que nada que ver, pues tan bobo no. Y rezando a Dios, no me lo hace dos veces. Lo más triste de la realidad, solo mentira, nada verdad. Me quedaba mucho por sentir, no creo que fuera necesidad. Que me quitaste la libertad, no porque no fue mi voluntad, pero se trata de vivir, o no. Después de todos los paris me llamas, diciéndome borracha que me quieres más. Y ahí odio que tu amiga me cae. Lo que fue prohibido lo aprovechan más. Si tú quieres beber, tengo filas hasta tres. No te necesito más. Te crees que yo lo sé. Sé que te digo, sé, pero hay más en Instagram. Si tú quieres beber, tengo filas hasta tres. No te necesito más. Te crees mucho, lo sé. Sé que te digo, sé, pero hay más en Instagram.
Good morning, good morning, good morning, good morning, good morning, y'all. Here goes Ted. Here he goes. I don't know why he does that. I do not know. Oh, Ted, come here, boy. Come here, boy. I'm like he literally have not barked all morning. Come here, boy. Come. Come here. Come here. Come here. Good morning, y'all. Good morning, Teddy. Let's see what's wrong with Teddy before we get started, y'all. I'm late. I'm gonna be running a little late, but I'm doing it for the channel. For the people who has not heard what's going on about this motion that was filed, which was a motion for an acquittal or a new trial. So all fingers got to stay crossed. All hands got to stay prayed up that this new motion will be granted so that Mr. Robert Sylvester Kelly can have a fresh start due to your government improperly using these laws to their advantage to find a conviction against Mr. Robert Sylvester Kelly. I hear, oh, he's quiet now. He's quiet now. I hear, and I see just like a lot of you people do, anger, bitterness, contradiction, slander, you name it. You name it. But, that just comes from a lot of people, in my opinion, taking on this case and applying it to their personal feelings, implementing themselves in a case, out of a case. This has been a roller coaster, you guys. It's been funny. Listening to people or a person read the motion and then add on their cliche to the motion is just, what I call a deranged, because you shouldn't want to do that, because had you been reading that in the court of law, to a juror, first thing that I'm going to want to know is, where'd you get that info? Why are we talking about that? Where'd you get that information from? And like I said, that's part of the bitterness, the angerness, people trying to resolve Mr. Robert Sylvester Kelly's case on their own, and doing nothing more but compromising a lot of things out here, right? Let's use for an example, Texas Black Diamond and the interview with Don Russell. That came in favor of the prosecution. The defense didn't put it in there. Came from the prosecution side. YouTube, in my opinion, should have just been left at YouTube. But because you have people that has taken this on personally and feels sometimes that they're doing something great, you're actually destroying a lot of things. You're compromising a lot of things. I always said, as I said and watched a lot of these people, well, you ain't the attorney. You're not hired PI. You're not this person. You're not this person. And why is all of this extra being done? Well, all of the extra caused a whole bunch of chaos on the YouTube streets, and it caused information put into legal documents where the attorneys and their assistants and things has to go and try to dissect or build their story more strongly against Mr. Robert Sylvester Kelly. You guys, hold on one second. Okay, sorry guys, I had to take that call. So that's just where we are today. What I do like is when the information gets dropped, where everybody can take time to read it verbatim, and that gives you the opportunity to side ask some people. What? Like I had to do last night, and I hadn't even read it. I'm going to read it, and hopefully I could drop the link, and some more people would come on the panel to take over of reading it because it's quite long. I'm going to be running late for the channel today, so that you guys know, 'cause I should be heading my nappy headed behind out this door. But I thought, you know what? Let's go ahead on and do it. She said, I'm looking younger. What's the secret? No stress. No, I have no stress. None. Even if the car run out of gas, I don't stress about it. I leave that goddamn car right there and go and get to walking, and or call a friend. I don't do no stress, girl. My life is pretty much smiles and laughter or something. I'm not saying I don't get, angry sometimes, or, here, near, or there. I do. But to be honest with you, with the YouTube, baby, I have been doing nothing but just laughing out here. I read the antidotes, I read the cliches, I read the subliminals, I read them all, and I just sit here and bust up, baby. Like, okay, okay, do your thing, do your thing. Anyway, let's get started because we need to. So let me go back here. Do, 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 do. Everybody knows that Attorney Jennifer Bunjean ended up dropping the information as scheduled. Good morning, everybody. Galatians Trevor. I saw, let me see, get my mods first. Beauty is here. So good morning. Everybody else that falls in, I will give you guys actually some shout out as we go through this. But I see each and every last one of you guys. So, but on the 17th, just as scheduled. So if she dropped that on that day, I'm gonna have to say this is a woman of her word. She dropped it promptly. Everybody was glued to the seats and fingers on the trigger of the Pacers account, which I also have myself. Just got to be careful with Pacer. There's a lot of things on there that you are required to buy, and some things that you can grab for free. I am not going to exceed a budget. Period. I'm a budget person, and let everybody else go grab it. So let me get the right one up on the screen. But she dropped it, just like she said that she was. She dropped it, and everybody has it. Everybody's been reading it. Okay, so here we go. I'm gonna open this here so that I can get some of my a lot of my information is not showing, which I don't have much, information. Good. Oh, it's good afternoon where you are, Cheryl. It's good morning over here. So the United States District Court end up well, Robert Sylvester Kelly's attorney, Jennifer Bonjean, ended up filing her motion on the defendant, Mr. Robert Kelly, of the law in support of, this is a motion for a new trial. I'm going to get it up on the screen in a second. Signed, documented by Jennifer Bonjean over at the Bonjean Law Group over at 750 Lexington Avenue, ninth floor, New York, New York, you guys. I think her name is really getting around out there too, you guys. She has really, really been standing before the courts for quite a few trials out there, quite a few people. So I wish her nothing but success on her journey as opposing to standing up and going at the judicial system on possibly wrongful convictions and the miscarriage of justice. They're using the laws to help them conquer a conviction against a lot of people out here. I have not quite came across a case where there is a female just of yet. I've been trying to dig, but most of it is standing up for a lot of the men rights out here, or basically let's keep it with the Constitution. She rides it hard, it appears to be, and she just wants it to be used effective when the prosecution is trying these people in the court of law. So much respect to Jennifer Bonjean. Let me go and share my screen with you guys. One thing that I do and I did like, let me say that I did absolutely like with Jane. When I say her and her team grabbed some case logs, she grabbed some case logs. You're not getting the notifications. You might have to subscribe, unsubscribe. I don't know, but I'm waiting on the screen to come up. You guys, she grabbed a lot of case logs, and I was like, yes. One thing about case logs, they are used as part of your evidence of what you're trying to prove in a court of law. Well, if they have this case against Mr. Robert Sylvester Kelly, right? Her and her team has taken time to find similar cases where this happened in this case, this went this way in this case. So now what it will show is disparate treatment. Well, if this went this way with this one, why is this guy the only way that is getting penalized on similar charges? You see what I'm saying? So I like that. Case logs are definitely a plus, because that tells me that somebody is doing their homework the right way and to win their case. And this case is Jennifer Bonjean as the hey, babe. As far as defending Mr. Robert Sylvester Kelly. Okay, so the screen is up. Let's go. The right here, she opened it up with her first argument about the defendant was denied effective assistance of counsel, where his trial attorney, everybody knows who his trial attorney was, okay, failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory, dangerous, I threw dangerous in, that shouldn't be there. Inflammatory docuseries, and dangerous came out because it was dangerous. It was a dangerous one due to putting out the this vision. Not only were able to hear these alleged females on this docuseries, it became poisonous to the brain, and the brain allowed a lot of people out there to illuminate this vision of things. So I threw that in there. It's not in the paperwork, so that's why it slipped out. I just wanted to explain why I put dangerous in there. Docuseries surviving R. Kelly, or were familiar with prior accusations of sexual abuse of minors against the defendant. Counselors' objectively unreasonable performance during voir dire resulted in the impanel of a jury that was neither fair nor impartial. Let me get over here. I need to blow. Where is my. I need to blow it up, y'all. Let me see if I can blow this up. Where is it? What is here? No. I'm gonna blow this up. On my others, when I do this one, I can't seem to find the goddamn magnifying glass. See, no, that's not there. Where the fuck is it? On all my other pages, I can find it. No. I don't know how well you guys can see it. You say you better not kill nobody. Her second opening argument was the defendant is entitled to a new trial, where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneously representation of the defendant and the government star witness. Jane was imputed to the entire defense team. So that was her opening statement as for her arguments. I got to find the goddamn mirroring. Where is my magnifying glass? Oh, hey, see, it's all the way over here. That's crazy. I found it. There we go, so that you guys can see. That's crazy. All right, put a thumbs up if that's big enough, you guys. I'm like, I know it's here, but I'm on a different document, so. Are we good? Can we see that, Beauty? Is it big enough? Big enough? Big enough? Good morning, everybody. Good morning. Here it just show you guys the cases that was pulled. Okay, thank you, Simply. The cases that she had pulled. So you'll hear these cases throughout her motion to show relevancy of the particular narrative, the particular sentence, the particular paragraph that she speaks of. And that's excellent work. When you're ending your paragraph with the period, you're done with that. You have to show where you believe that where your factual findings are. So if I drop a paragraph and I say, hey, i.e., report over here, this is where, I found information, that will relate to what I'm saying, where you guys, where I stand my truth at. There's my findings. So you'll hear a lot of the cases throughout the motion. And this is crazy because, she pulled. There's a lot of them, you guys, which I'm interested in. So I will be pulling at least one or two of them, depending on where I am with her motion that I'm interested in. Like, the females, the mama and the daughter. Hey, Harlem. So Let's get the ball going. Introduction. It is axiomatic that a defendant, let me drop this link in here in case somebody wants to come on and help me get through this so I don't be too late for work. I'm finna be late, y'all. I'm gonna be late. Okay? It's an axiomatic that a defendant is entitled to the effective assistance of counseling. U.S. Constitution Amendment 5, and that's Amendment 5. Everybody know their Roman noodles, Roman numbers, right? Everybody knows that. You know what the XXX 11. Just so you guys know, but right here she mentioned Constitution Amendment 5, incorporated in the defendant's Sixth Amendment guarantee is the right to conflict counseling. Defendant was denied his Sixth Amendment. So, if you read your Sixth Amendment, it's pretty long. You have to go deep into it to understand how she came up with his Sixth Amendment being denied here by the government in a number of ways, some of which are clear from the record, some of which are not. In complex RICO prosecution, defendant's legal team fell apart mere weeks before the commencement of trial. The docket reflects that the defendant's lawyers were unable to effectively represent defendant as a team. Energy, resources, and time that should have been devoted to preparing for trial were expended, battling each other until two of the defendant's more experienced attorneys were granted leave to withdraw. Defendant was left with a disjointed, unprepared trial and no singular defense strategy. What that means is that he was left with, I'm going to do it in our language, one head Negro in charge. You feel what I'm saying? Because she brought in to talk about how, the conflict of interest as well. So had Mr. Roberts of Kelly literally had, one chief, calling the shots, moving timely on motions and things like this, just maybe he would have not had an expendable trial off of different or many attorneys. You know what I'm saying? So, yeah, let me see. We're doing the motion, right? I'm doing the motion right now. So if you're coming in to sit on that, then that's fine. But that's what we're doing. This motion identifies two series of violations of the defendant's Sixth Amendment Constitution. It guarantees that require a new trial. So now we know that she's using the Sixth Amendment of the one of the miscarriages of justice, stating that Mr. Robert Sylvester Kelly should be granted a new trial based off of that Sixth Amendment alone. That required a new trial and are apparent for the records. Specifically, defendant is entitled to a new trial where his trial team conducted no meaningful voir dire. Do everybody know what voir dire means? Because I'm going to look it up and let you guys know exactly what does it means in legal terminology. And then I'm going to keep just reading it. It means that it's a preliminary examination of a witness or a juror by a judge or counselor. So everybody can know when you hear that word, voir dire, a preliminary examination of a witness or a juror by a judge or counsel. Thank you, D. Ferris. Shorten it up. And acquisite to the seating of jurors who were unqualified to serve on this juror. Unqualified. A defendant was also denied conflict-free counseling where his attorney, Ms. Becker, simultaneously represented one of the government's key witnesses. The violation of defendants' Sixth Amendment rights are so serious as to demand a new trial without a showing of prejudice. Ooh, legal standard. Federal Rule of the Criminal Procedure 33 provides that upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. The interest of justice is Jennifer Bonjean. Requesting, everybody knows, this new trial due to the fact that her and her law firm as an attorney feels that Mr. Robert Sylvester Kelly's Sixth Amendment rights had been taken away from him. I'll say that. Unlike Rule 29, Rule 33 confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice. But such discretion should be exercised sparingly. And of course, she now resort back to one of her case logs that she pulled, United States versus Sanchez. Defendant was denied an effective assistance counseling where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom that he had watched the inflammatory docuseries. Wow, okay, so the jurors, I guess, watched the docuseries Surviving R. Kelly, or were familiar with the prior accusation of sexual abuse of minors against defendant. Counselor's objectively unreasonable performance during the voir dire resulted in the impanel of jury that was neither fair nor impartial. As the United States Supreme Court Justice Black in R. Michael, another one of her case logs, it is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case. That is, his due process means a juror capable and willing to decide the case solely on the evidence before it, and the trial, meaning that they decided prematurely, already decided, this is her opinion, that these jurors, impartial or partial, being that the docuseries had already came out, it's no way impossible, in my opinion, that a lot of people just did not see it. I'm going to be under the impression, because we're talking about Lifetime, and Lifetime is a number one broadcasting information show out there, so it is possible that this juror that she states did probably catch a glimpse of it and prematurely had already been, I'm going to use the word brainwashed, before the selection of the juror. And it's easy to say, if you're asked the question, have you seen this, or have you, everybody, okay, tells a little fib or whatever. And this was a big case. So you can imagine that there's probably some jurors on there, sorry, you guys, that really wanted to take part in this case. And then they'll turn around and say, well, no, I don't watch much TV. Yeah, okay. I'm coughing now. So let's finish. That is because due process, a juror capable and willing to decide the case solely on the evidence before it. Where's my cup? I'm choking, you guys. And willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudice occurrences and to determine the effect of such occurrences when they happen. Her next source case log she pulls up, the Smith versus Phillips and Irwin versus Dowd. The United States Supreme Court observed the right to a juror trial guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true. Regardless of the heinous of the crime charge, the apparent guilty of the offender or the offender, I'm sorry, of the offender or the station in life which he occupied. A jury who has formed an opinion cannot be impartial. Internal citations omits that. So, rule number 24, she goes on as of the federal rules of the criminal procedure governs voir dire in criminal trials. The rules provide that if the court examines jurors, it must permit the attorney for the parties to A. Ask for the questions that the court considers proper. B. Submit further questions that the court may ask if it considers them proper. Fed R. Criminology is just short, page 24. You can look that up to see if that is true. A trial judge who, under Rule 24, decides to examine prospective jurors himself must at the very least solicit questions from both parties. I'm going to ask the chat before we go on. Do you guys feel that Judge Donnelly did as such? I actually put a 1 in the chat if you did, put a 2 in the chat if you did not. Did she, Judge Donnelly, properly, where it says a trial judge and under the Rule 24, decide to examine prospective jurors himself, must at very least solicit questions from both parties. So, do you guys think that the judge delivered questions from both parties? What do you guys think? No. Everybody says no. Okay. Must and she found this here to bag this up of her factual statement coming from this Rule 24 under the United States versus Lard, and that's from the Sixth Court back in 2007 is where she finds this information to bag up what she states here under the Rule 24. Naturally, the trial court's duty to ensure that each and every juror is fair and impartial is heightened, whereas here, pre-trial publicity has greatly increased the odds that a potential juror has preconceived views of an accused's guilt. You guys understand what she's saying there? She said that the pre-trial publicity, where did most of the publicity come from? Your main media stream out there. They were dead on it. They was putting it out there. Boom, here comes a Lifetime. Here comes the Shabazz. I don't want to throw him in there, but here comes his show that came out to put some influence on it, and it could have been a great possibility that the jurors may have seen this information prior to the trial. In an effort to protect defendants' cherished guarantee of a fair and impartial juror trial, this court implemented a procedure whereby potential jurors were asked to complete questionnaires that probed whether they had prior knowledge, preconceived notions, or bias about defendant giving the unprecedented pretrial publicity he faced. That was in docket number 115. So indeed, the questionnaire contained an entire section entitled Knowledge of the Case and People that asked jurors to reveal whether they had read, seen, or heard anything about the case, the alleged crimes or people involved, and to describe in details any information they had previously learned by the defendant. The questionnaire expressly asked prospective jurors whether they had watched or heard any interviews of Robert Kelly, of any TV shows featuring him, or any specials or documentaries about him. She goes on to say that the court invited counsel for the government and the defendant to review the questionnaires in advance of the juror selection and determine whether they could agree that the certain individuals should be excluded for cause. The parties conducted the process and identified a set of potential jurors for the voir dire process. Inexplicably, defendant's counsel failed. The defendant, I'm going to repeat it again, the defendant counsel failed to challenge several jurors who ultimately sat on the defendant's juror who were clearly unqualified to serve on an account of their preconceived beliefs about the defendant's guilt. These decisions cannot be justified by trial strategy where the record fails to reflect that trial counsel conducted a sufficient inquiry to probe these jurors' biases. Indeed, trial counsels were mostly silent throughout voir dire. Mm, mm, mm. I don't think she's trying to throw them all under the bus. I think that she is just questioning their the authenticity of the lawyers. There was room there behind given the questionnaire pertaining to the jurors. There was some wiggle room there for the defendant, and we all know who the defendant is Mr. Robert Sylvester Kelly. They did not take the opportunity, I think is what she's saying, to, question, I object, or, clean up some of the questionnaires that was being presented to this juror. Okay? So that's what I get out of that. She's not throwing them under the, well, she spoke on them. These decisions cannot be justified by trial strategy where the records fails to reflect the trial counsel conduct a sufficient inquiry to probe these juries' biases. Indeed, trial counseling was almost silent. I'm going to have to highlight that part on my paperwork, girl. Although the court was responsible for questioning prospective jurors, it afforded the parties the opportunity to weigh in the questioning of prospective jurors who had made representations in their questionnaires that raised red flags. These questionnaires were highly effective tools for putting the parties on notice of jurors who might not be qualified to serve. But trial counsel made no effort to drill down on troubling representations that demanded further inquiry to ensure that the juror could be fair and impartial regardless of any general assurances he or she provided to following the court's instructions. What does she mean by regardless of any general assurances, you guys? Fact checking. Fact checking. Even though they may have questioned this juror, well, where do you live? Well, what color is your hair? Well, how tall are you? Well, what was the last TV show that you watched? And then she feels that there was more wiggle room, in my opinion, to do some further investigation, behind the selected juror to make sure that this juror was not going to be biased on the stand as they sat and listened to Mr. Robert Sylvester Kelly's case being presented by the prosecution. So that's my opinion of it. Perhaps most troubling, most of the defendant's jurors were aware of prior allegations of sexual abuse against him. Really? She says most of his juror, the defendant's juror, Mr. Robert Sylvester Kelly, they were aware of prior allegations of sexual abuse against him. Oh, well, couldn't something happen to these jurors? Like, What can possibly happen to the juror knowing that they went up in there under the false pretense of presenting themselves as if they knew nothing about this man's case? What can happen to a juror? Had actually seen a scathing one-sided docuseries entitled Surviving R. Kelly that portrayed the defendant as a serial predator and included interviews with many of the government's witnesses. Albeit outside the adversarial process, defendant's jurors should not have included a single person who saw the documentary Surviving R. Kelly. It defies all logic that a juror could possibly remain indifferent, one-sided, and consider only the evidence heard from the witness stand after watching this docuseries. But this court could not make cause challenges for defendant or do defense counsel job for it, although it tried at points. It was defense counsel's responsibility to conduct a meaningful voir dire, particularly in this highly publicized case, to ensure that defendant's juror was fair and impartial. Trial counsel, the trial counsel failed in its duty. Oh, God. And she holds no bar and went 10 toes down on that one. She ain't pointing no fingers to each individual. Not just of yet, because I ain't got to that part yet. Now, I don't see her mention, like, who dropped the ball. Who dropped the ball, y'all? Hashtag the name in the chat room. Who do you feel out of the defendant's legal defense, who dropped the ball? For example, she talks about juror number 3. Provided the following information in the questionnaire. The first question to juror number 3, question 29. The case for which you are summoned involved the defendant Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? The answer from juror number 3 replied, I watched the documentary, but I forgot the name of it. Let me see them thumbs down in the chat for juror number 3, you guys. Put the thumbs down in the chat for juror number 3. Juror number 3. The question was from question number 30. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? The answer from juror number 3 replied, yes. Oh, entertainer? I heard that he has been sleeping with underage girls. The question for juror number 3, question number 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Reply from juror number 3. Yes. Question. What was your general impression? Answer from juror number 3. I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. Question number 9, imposed to juror number 3. Do you know anything about the Me Too movement? Juror number 3 answers, well, yes. It's a movement that seeks justice for rape victims 25 to 30 years after the fact. Trial counselor did not ask the court to question the jurors further about his responses to these questions or to determine whether the juror could truly serve as impartial and unbiased. Juror in light, speaking about number 3, having seen the salacious and highly prejudicial docuseries, not a single question was asked of the juror about his impression of the documentary. I struggle with that damn word, y'all. Documentary. Nor did counsel ask the court to inquire about what information he had learned about the defendant's prior legal issues or his reputation for sleeping with underage girls. Frankly, anyone who had seen the docuseries should have been automatically removed for cause. Just cause. Put a 1 in the chat if you agree with her. Put a 2 in the chat if you do not agree with her. Juror number 4 revealed in the questionnaire. Question number 39. Juror number 4. The charge in this case, it involves allegations regarding exposure to one or more sexual transmitted diseases. Is there anything about such an allegation that you believe, juror number 4, would affect your ability to serve as a fair and impartial juror? Juror number 4 reply was yes. I find transmission of STD in a non-consensual act to be particularly repulsive. Most of you guys have heard the motion. She's going to come and put her work down and showing the people in her motion on a few these allegations were consensual. But here you had juror number 4 had already decided that transmission of STDs is non-consensual without not even knowing if it was consensual or not. Hello, people. Can I get a hello in the chat? Hello, people. Everybody put hello in the chat. Question number 5. I could respond on how juror number 4 should have responded to that question. It was simple, easily, by saying, well, I don't know if it was consensual or not. That would have made him a non-biased candidate for this juror. I'm just saying. Question 55 was asked to juror number 4. Have you ever known anyone, including yourself, who was the victim of a sexual assault, other assaults or homicide, or other acts of violence that required medical treatment or counseling? Juror number 4 replies, yes. Close friends received asylum due to sexual assault and infections with HIV from the police in a foreign country. Question number 7-8 to juror number 4. Well, which public known person do you least admire? Number 4 responds with Jeffrey Epstein. Well, although the court generally asks whether anything the juror read would affect his or her ability to be fair and impartial in the case, and the juror replied, not that I know of, but the trial counsel did. The trial counsel did not ask the court to question the juror whether his feelings of repulsion about the transmission of STD is a non-consensual scenario would interfere with his ability to serve as a fair and impartial juror. No conceivable reason exists for failing to inquire further about the juror's feelings. You can't go into this shit with feelings. You cannot. You cannot. It will bring out every side of your biasm. I guess I'm going to put an ism on there. Yeah, it will bring it out. She goes on by saying, No conceivable reasons exist for failing to inquire further about the juror's feelings, about the transmission of the STD in non-consensual circumstances where the government charged defendant with precisely that act. Incredibly, this juror willingly disclosed the publicity known person he least admires in Jeffrey Epstein, an accused pedophile, just like the defendant, with no meaningful inquiry about whether this juror could truly serve as a fair and impartial juror. The juror was seated. She went on to juror number 5, disclosed the following in his or her questionnaire, being very careful not going against the sequestered juror, meaning that Jennifer Bonjean is very good without identifying furthermore whether each one of these jurors were a man or a woman. So shout out to Jennifer Bonjean. She stuck to what the judge requested, which was a sequestered juror. Nobody gets to know who, what, when, where, or why, of their nature, except for them being known as peers to Mr. Robert Sylvester Kelly. So shout out to her for that, so that she wouldn't be in any violation of breaking the law. Okay? I like that word. Bundago. So, juror number 5 was hit with question number 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Juror number 5 replies, yes. Whoa. Well, what were your general impression? Second question to juror number 5. Oh, he loves underage girls. Question 32 was hit to juror number 5. For what you have seen or heard, do you have a general impression of the defendant? Answer to juror number 5. Somewhat negative. Whoa, prejudgment, you guys, prejudgment. Question, why do you feel that way? Juror number 5 answers in a reply, the allegations that related that he was sleeping with underage girls, minors, although the court asked the prospective juror general questions about her ability to put aside other things she might have heard. Juror number 5 was asked, put it aside. Put aside your personal feelings, but she couldn't do that. She couldn't do that. Hold on one second. One more time, you guys. I got another important phone call, so give me a second. Okay, so where were we? Yeah, she couldn't put aside, well, he or she could not put aside the personal feelings. So when asked if she could be fair, the juror indicated that he or she would give it a shot. He or she is going to give it a shot. The best that she or he can do. We're going to give it a shot. The court reminded the juror that he or she had to be certain that hold on, juror number 5, hold on now. It says we on juror number 5. Did y'all catch that? It says that the court reminded the juror that he or she had to be certain that she would consider only evidence offered at a trial. Wah, 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 wah. So, what gender is juror number 5? Let me see how many people caught that. What gender is juror number 5? Huh? What juror? What gender, y'all? Hmm? Did you catch that? Anyways, let me keep going. Y'all so slow. Y'all slow. Slow, slow, slow. Oh. That she would consider only evidence offered at a trial and the juror acquiesced. Incredibly, the court seemed very concerned about this juror's ability to be fair. Get D, you on it. Thank you. I got people in the chat room sleeping. Wake up, y'all. I'm the one running late. Wake up. Female, where am I at? The court okay, we did that. Incredibly, the court seemed very concerned about this juror's ability to be fair. Observing, so I don't know about you, but when someone says that they think that they can do something in this context, I don't think that that's an unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we will still end up with, I think so, from the government if you have a position on that. Not surprisingly, the government was confident that the juror indicated she could be fair. This is a female, y'all. Juror number 5 is a female. The court still expressed doubts. Inexplicably, trial counsels agreed with the government, and the juror was seated. To be blunt, defense counsel agreed to the seating of the juror, who not only watched the surviving of R. Kelly, but concluded the defendant loved underage girls. I'm going to read that again so that you guys can see her position of her playing out where it's possible and allegedly that Mr. Robert Sylvester Kelly had some ineffective defense. That's all I'm saying. That's just my opinion. That's all I'm saying. I'll repeat it again. She says, to be blunt, the defense counsel agreed to the seating of a juror who not only watched the surviving of R. Kelly, but concluded that the defendant loves underage girls. So there simply cannot be any raw strategy for failing to excuse this juror for cause. Had trial counsel challenged this clearly unqualified juror, the court seemingly would have struck him or her for cause. Trial counsel not only didn't move the disqualified the juror, he did not even ask to probe more deeply into the juror's statement on the questionnaire that the defendant loves underage girls. I ask again so that we will know and people would go back to watch this live. Who was the defendant trial attorney? Who was the defendant trial attorney who failed to dig further into these questionnaires to have some of these jurors dismissed from having the opportunity to stand as a juror as being biased on this juror for Mr. Robert Sylvester Kelly? Who was he? Who was it? Who was it? Huh? Which one was it? There simply cannot be, we did that, okay, let's go here. Trial counsel not only didn't move to disqualify the juror, it was a he. He did not even ask the court to probe more deeply. She says it was a he. A he. She stated his trial defense, she said he did not even ask the court to probe more deeply into the juror's statement on the questionnaire that the defendant loves underage girls. She moves on to juror number 7. Also revealed in his questionnaire that he had heard about the case and the alleged crimes. Trial counsel did not ask the court to question the juror further about what he heard specifically or where he heard it. Number 7. Thank you, D. She on it. She on it. Thank you, D. Ride with me here. Ride with me. The court merely asked the juror whether he can put aside what he heard and rely on the evidence presented in the case. We know what the R 152 through 153. Juror number 8 also disclosed that he or she had heard about the crimes. Defendant is alleged to have committed and further indicate that he or she believed that the allegations related to another case in another state. Again, trial counsel failed to probe what precisely the prospective juror had heard or conduct a meaningful inquiry into whether she could be. There's another female. She could, so juror number 8 was a female, could be fair giving what she had heard. Number 8 is a female. Now, I'm going to stop there because I just have a quick question right quick, you guys. Just a quick question. Because right now she has this motion in for an acquittal or, or a retrial, okay? So my question to you guys, because Mr. Robert Sylvester Kelly case had the trial, the Lifetime docuseries is still out, and all of this YouTubing and Instagram and media and stuff have been going on. Who's to say that Mr. Robert Sylvester Kelly will have another impartial, bias juror? You know what I'm saying? So I'm shooting for, at this point, acquittal. Done. Because I don't know if I'll be able to trust another selected juror on behalf of the judicial system. I don't know. Not in this case. I don't know how you guys may feel about that. That's how I feel about that. This is big. This is large. It's even international, you guys. Where are they going to find where an unbiased a juror at now? Where? I'm just saying, throw the whole thing out. Acquittal. Exactly, D. This has to just go away because I wouldn't even trust the next juror. We all in there and say, I do, I really do, and Lord help me for God. We all say that. I'm just saying. Having another one for what? Juror number 11. Let's see what juror number 11 is up to. Similarly disclosed that he or she saw the case mentioned on the news when he was first being investigated. And she, another woman, had read or seen that he had allegations of misconduct lodged against him. Shockingly, trial counsels did not ask the court to follow up on any of these important revelations to determine whether the juror was qualified. Number 12. This is juror number 12, offered several concerns concerning answers in response to the questionnaire. Number 12 was given question 29. Have you read or heard anything about the case, the alleged crimes or people involved? Number 12, and juror number 12 replies with a yes. The question describes in details what you recall seeing or hearing about, etc. Answers: sex with minors. Specific details did not come to mind. Parodies on TV regarding details of defendant's personal life. Saw the Dave Chappelle, SNL, was in jail prior to, then released. So that's all what juror number 12 went on to describe about what he or she had heard or seen pertaining to Mr. Robert Sylvester Kelly. Juror number 12 was hit with question 30. Have you read, seen, or heard about Mr. Robert Sylvester Kelly? It says R. Kelly. Answer was yes. Same answer as above. Various instances of an achievement in music career, songs on the radio, video, entertainment, never showed, news shows, specifics are not remembered. Number 32 was given, number 32 is the next question. Question 32 is the next question to juror number 12. From what you have seen, read, or heard, do you have a general impression of the defendant? The answer, somewhat negative. Question why? Answers, I really never cared one way or the other regarding the defendant. The somewhat negative impression is an emotional one impact that the nature of the charge against him. Juror number 12 was also given question number 91. Do you know anything about the Me Too movement? Answer, entertainment industry led movement encouraging when to come forward and name their accusers. Associate it with accusers of Harvey Weinstein, various news articles, and TV news segment. The trial counsel questioned the juror about his or her ability to be fair and obtain assurances from the juror that he or she could. But the trial counsel did not bother to ask the court to inquire about the juror's reference to the defendant's personal life. Sex with Minors, or Dave Chappelle SNN skit, which referenced prior allegations against the defendant of videotaping sexual encounter that depicted him urinating on a minor, a crime from which he was prosecuted, although not convicted. It is beyond comprehension that the trial counsel would not have sought to inquire further of this juror about his prior knowledge about allegations against the defendant or press whether he could truly be fair giving the information with which he came to the juror. Nearly all of the alternative jurors admitted that they were aware of allegations of sexual abuse against defendant. In fact, one of the alternative jurors stated, no, there have been accusations related to this for quite some time. Think, defendant was married to Aaliyah, who was underage at the time, and further admitted that she, another female, had seen defendant's interview with Gayle King in which he stood up and yelled to defend himself. Although the defense counsel indicated that he intended to challenge this alternative for cause. No motion was formally made, and the alternate remained on the juror. Woo cha, woo cha. I mean, I know she ain't trying to throw nobody under the bus, but baby, she is putting them out there based on how ineffective they were to defend their client. I'm just saying. Ooh, cha. Oh, cha. I would be somewhere with my head in the bag if I was them. Like, okay, ooh, this got to go away. This woman is calling out our inexperience of questioning a juror. Critically, alternate juror number 4, well, I couldn't hear it. I want to get to that y'all. She revealed that she was aware that the defendant was married to Aaliyah when she was young, but claimed that she had not really heard much about the case and assured the court she could be fair. Again, the trial counsel had no follow-up questions for this alternate juror, juror number 4. Notably, this juror apparently was familiar with well-known Me Too lawyer, hush your mouth, Gloria Ari, who represented some of the government's witness and asked if she can get Allred's autograph in the middle of the trial. Juror number 4. Juror number 4. Holy caboose, y'all. This you had a juror number 4 allegedly that the defendant counsel, prior defendant counsel, possibly knew that juror number 4 had some type of association, going on. No, number one, knowing the Me Too lawyer, huh? Oh, Lord, if they don't throw this shit out, just that right there compromise this shit. Just that right there is grounds. Asking for the goddamn Allred's autograph. This whole shit should have been ineffectively to move. Case dismissed. Sorry. The jurors came in there and messed this all up. The jurors, right? And I don't know how the judge feeling about this right now. Oh, y'all. Yeah, she aired that dirty laundry, girl. I didn't put that song on. Defendant had no chance to defend himself, where most of the jurors in this case were fully aware of his prior legal issues. Some had watched the damning docuseries Surviving R. Kelly and may seem to accept that he was known for abusing minors. Frankly, anyone in the courtroom seemed to accept that the defendant's juror would be prejudiced against him and made virtually no effort to impanel a truly unbiased juror. Although the court generally asked the jurors about their ability to be fair, it was counsel's job to elicit as much information as possible to determine whether the juror could actually be fair. And they did not do that. They allowed these jurors to be seated. As stated previously, in a case of substantial pretrial publicity, jurors' subjective assessments of their own impartiality may not adequately screen from the possibility of prejudice. And she pulled a source, her case log up of Waldorf Third, F page F on 3D in 710. You will find that she made it quick, easy for you guys to pull this research up and go ahead and show where she relates this to this and how ineffectively the counsels did with this goddamn juror, these jurors. She gave it to you right there. So let's move on. Voir dire plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial juror will be honored. Another case law, Rosales Lopez versus United States. She gives you exactly where you can go to find that information. As early as 1995, Supreme Court in Connors versus United States explained that an adequate voir dire is essential, meaning imperative. You got to have that part going on in a trial. You do. To ensure that the prospective jurors will be free of bias or prejudice and will perform their duties impartially. The primary purpose of the voir dire is to make possible the impaneling of an impartial juror through questions that permit the intelligent exercise of challenges by counsel. United States versus Blonde. The defendant received ineffective assistance of counsel, where his trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure that they were free of bias or prejudice. Counsel also failed to challenge jurors who were clearly disqualified from serving, including those who had seen the highly prejudicial documentary Surviving R. Kelly to prevail on a claim of ineffective assistance of counsel. A defendant must demonstrate both that his attorney's representation was unreasonable under the prevailing professional norms and that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceedings would have been different. She finds that in one of the case logs of Strickland versus Washington's for to use as her comparison, you guys. Trial counsel's performance was unreasonable under prevail professional norms where he failed to question clearly biased jurors about the extent of their knowledge about the defendant's prior legal issues. Allegations of sexual abuse and their feelings about the documentary our attorney cannot make an intelligent decision about whether to challenge a potential juror for a cause or whether to exercise the defendant's peremptory challenges without properly questioning potential jurors to learn of potential biases. In this case, numerous jurors divulged that they had prior biases from having learned information about the defendant through other sources prior to the juror selection. Their own subjective assurances they that they could be fair was not sufficient to ensure that they did not harbor beliefs or preconceived ideas about the defendant's guilt. Significantly, one alternate juror says, "Me too, Lord Glory Allred in the courtroom." Allred represented a few of the government witnesses and was a common fixture denominator on all media platforms, declaring the defendant the worst predator she had ever pursued. Boy, she called that goddamn, she called the glory out, y'all. So during the middle of the trial, the juror asked the courtroom deputy if she could obtain an autograph from Allred. When asked by the court why she wanted the autograph, the juror responded, "Because I admire her." Just cause you know other cases I've never heard. I didn't even know she was going to be here. I just admire her for what she's accomplished. This was the same alternate juror who admitted during the juror selection process that she knew about allegations against the defendant and specifically that he was married to Aaliyah when she was underage. The trial counsel belatedly sought to remove the jurors, stating, "I can think of anything more disqualifying than a juror asking for the autograph of one of the attorneys who represented one of the witnesses." It speaks to a bias for the prosecution witnesses, and for that reason, I would ask that she be removed. The request was denied. She was to be held on as a standby. The trial counsel was, of course, corrected that the juror clearly evinced a bias against a defendant in the favor of his accusers. But counsel fails to ask the court to question the juror during voir dire more extensively about her knowledge of defendant's marriage to Aaliyah and her feelings concerning allegations of the sexual abuse made it impossible for the defendant to gather an accurate impression and make an educated decision about whether she was qualified to serve. Had counsel competently questioned this juror, he likely would have learned information that revealed a bias consistent with her request to obtain an autograph from Allred, a woman who she admired, who called defendant the worst predator she had pursued. Defendant had demonstrated prejudice by trial counsel's failure to conduct any meaningful voir dire where his jury was comprised largely of people who were seated with an understanding that the defendant was a sexual predator. Because the defendant cannot possibly prove the likelihood of success if his case was heard by a fair and impartial juror. Prejudice must be presumed. Trial counsel abdicated all responsibility to conduct a meaningful voir dire, which resulted in a jury that was largely unqualified to serve. The United States Supreme Court has recognized that in certain Sixth Amendment contexts, prejudice is presumed, actual or constructive, denied of the assistance of counsel altogether is legally presumed to result in prejudice. So hold on, you guys. 1 second. Okay, I'm back, you guys. So we go here. The trial counsel abdicated all responsibility to conduct a meaningful voir dire, which resulted in a jury that was largely unqualified to serve. The United States Supreme Court has recognized that in a certain Sixth Amendment context, the assistance of counsel altogether and legally presumed to result in prejudice. Case log Strickland 466. This case is one of those rare cases, according to this court, should vacate the verdicts of guilt and grant defendant a new trial. Okay, what time is it, you guys? It's 11:38. I'm going to continue reading this, but since I don't have help reading this right now, I'm going to have to pick it back up here at explanation of number 2 of this paragraph here. So you guys have at least the beginning part of it. Most of you guys have heard quite a few of the motion around on the YouTube streets, but I think that I need to get the word because I don't want to put you guys to sleep over here. And I'm enjoying reading it and getting a better understanding of this motion to acquit this trial. But I must go. You guys are good with that? I'm going to pick it back up tonight. I'll be back on tonight about 8 o'clock. Then I don't have to rush through it. I can take my time, sit here, chill with you guys, and we can develop our own opinions or questions about the paperwork like I was doing. Everybody good? It's 11:30. I got to get the hell up out of here. I got to get the hell up out of here. Y'all give some shout out for attorney Jennifer Bonjean for this impeccable motion that was written up, dropped timely as expected. And we're going to leave that here. Cool? Priscilla, Harlem, you guys are cool with that? Y'all cool with that? Beauty? I think Beauty had to go. And this can take a while, you guys. You say kick their ass at home. Boom, baby, boom. Boom. Sounds good. Okay, Hill. All right. I got to go. I got to go badge in. I got to go badge in. Lady, thank you, thank you. So I hope to see you guys back again tonight. I will be sitting here and read this. Okay, Priscilla, I will. All right, you guys. So we're good. Hashtag free R. Kelly. Bye, you guys.